Welcome everyone to this educational webinar provided by Foley and Lardner LLP. Today's topic will be the Persuader Rule and a critical deadline that is approaching. Hello, my name is David Pulio and I'm a staff member with Foley and will be assisting with the administration of this webinar. Before we begin, I would like to go over a few housekeeping items regarding the logistics of this program. Today's program will last approximately 1 hour, followed by a short question and answer session. We do encourage you to submit written questions during the program. Please type your question into the Q&A widget, which should be open on the left-hand side of your screen. We will respond to those questions at the end of the program. The webcast console you're looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience any technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window. It's designated with a question mark icon. The PowerPoint presentation will be available on our website at foley.com within the next few days, and you can also find a copy of the slides in the resource list widget open on the left-hand side of your screen. You will also find a complete bio of our presenter and links to Foley's newsletters and our practice blog as well if you wish to stay up to date on this topic. As another reminder, we will be recording this presentation and putting that recording up on Foley's website within the next few days. So at this point, I will turn it over to Kevin Hyde, the chair of our Labor and Employment Practice, to introduce our speaker for today and to give us an overview of the topic at hand. Thank you again and enjoy the webinar.
Good afternoon, everyone, and thank you for joining us. And I understand and realize this was on relatively short notice. As you may have heard, over the last week or 10 days, there's been some movement in the union persuader rules and an opportunity under the now published regulations to take advantage of an exception which applies to union agreements relating to these union persuader rules, but they must be done on a very timely basis, that is before July 1. Today's presentation is going to feature Greg McClune, who is a partner in our San Francisco office, who has spent his entire career doing traditional labor work, so he's very well versed in these matters. And he's going to walk through the intricacies of what is necessary to take advantage of this exception right now and what it may mean for employers. So we appreciate you coming on with short notice. Please type in any questions you might have, and Greg and I will do our best to answer them. And, of course, we will be available for any questions or consultation, not only during the presentation today, but also any time after that. With that, let me turn it over to my partner, Greg McClune. Greg?
Hi. This is Greg McClune in the San Francisco office. And for those most in the call, good afternoon. And for the clients in California, I know who you are. Good morning to you. As Kevin said, I've spent my career in the labor and employment, particular labor area, and this has been, quite honestly, a fairly sleepy part of the law for many years, but has become quite controversial in the last few years. We will not be spending a great deal of time on the substance of the Persuader Rule. There's been a lot of material out on that. The principal purpose of this presentation is to focus in on a very recent development in the enforcement of the rule that has caused a lot of consternation. And quite literally, it only became apparent generally last week. And so this is a very new development. It is, as Kevin mentioned, the question of to what agreements will be covered by this rule, and it affects both agreements with attorneys and consultants. So that's going to be the principal purpose. We will be talking somewhat about the Persuader Rule to understand and general outline what this new rule means and the changes that have been affected by the interpretation that was published in late March of this year. The other thing I'd like to let you know is there's been a very recent development in the 3 lawsuits that are challenging the rule, and towards the end of this presentation, I'll discuss those cases and indicate what the new developments have been there and what expectations we can have with regard to those challenges. That wasn't the original purpose of this presentation, but it's become almost as interesting as this grandfathering provision that we'll be talking about. And I'll just, so the first question is, what is the Persuader Rule? And a little bit of historical background to put it in context. The rule arose out of legislation that was passed in 1959. The principal purpose of the legislation, the Labor Management Reporting and Disclosure Act, was to address perceived abuses that were occurring in labor organizations. And so most of the statute addresses reporting by unions. And for those of you familiar with this area, the LM2, which is an annual document a union has to file, which is a mine of information regarding the unions, arose out of this statute. There was also, as part of it, maybe it was a sort of balancing part of it, was that there was a concern at the time that there had developed in this field, the field of union organizing, consultants who were known then as middlemen. I don't think that term is around nowadays, but middlemen had a bad history. There were apparently abuses occurring, and one of the abuses was that some more unscrupulous employers would hire these middlemen on the guise of being genuine employees, and they would insert them into the workforce, and they would disguise their real intent and would engage in surveillance and also in other conduct which would upset union organizing. So this was a concern, and the Persuader Rule was designed to address that type of abuse. And as far as I know, that hasn't happened in years. In all my career, I haven't heard of middlemen engaging in those sorts of activities, but the rule continues to live on, and now, as we'll see, has been modified to cover other conduct. The rule determines what is persuader activity performed by a consultant. The term attorney is not used in the Act. It's consultant, but consultant is broad enough to cover an attorney. When there is an agreement to perform persuader activities, both the consultant or attorney must file detailed written reports with the Office of Labor Management Services, which was created pursuant to this Act, which is an agency in the Federal Department of Labor. The public has access to these reports, so employees and unions have access to them, and that was one of the intentions of the Act, was that employees in particular could be made aware of what the employer, who they were employing, and what they were paying to consultants. The other aspect, which is really important, is that the employer and the consultant must retain records for 5 years. So that's an we will talk a little bit later about the content and the change in the rule, but just for the moment, I'm going to discuss the consequences of non-compliance, and these are pretty severe. And there's one aspect I think that would worry me if I were a corporate counsel or HR executive. The Act states specifically that the personal responsibility for accurate reporting rests on the employer's chief executive officer and chief financial officer, or the equivalent in the organization. So if this means if a report is not filed or a report is filed with inaccurate information, your CEO or CFO will be held personally responsible for that misfiling. And the consequences, certainly in theory, are pretty severe. Willful violations can result in criminal prosecutions with fines up to $10,000 and 1 year's imprisonment, or both. To be honest, I've never heard of a prosecution in this area, but then, as I said, this has been a pretty sleepy area of the law, bit of a backwater. it is not anymore. It is getting a lot of attention and has for the last 4 or 5 years. I could comment a lot on that and maybe some questions on it, but it is almost certainly a political issue. It's one of a number of areas where the Department of Labor, acting, I'm sure, on the instigation of the current administration, has become much more activist in trying to control employers and to provide a more favorable atmosphere for union organizing. Moving on to the consultants who do not report, there's largely the same consequences for not reporting. That is that there can be criminal prosecutions, imprisonment, fines, and personal responsibility for accurate reporting. There is an area of the law which has been in the past very controversial and will become even more so. And it's one thing I'd like to stress on this presentation because it's counterintuitive, and when I explain to some people, they are in disbelief when I tell them this. One of the consequences of a consultant performing persuader activity, if any consultant performs persuader activity for any employer, that consultant must then report not only the agreement with that employer, plus receipts and disbursements, but also must report receipts of any kind and disbursements of any kind from any employer for whom the consultant has performed labor relations advice or services. Now, note that that second part is not persuader activity. So the example I would give is if consultant or attorney A does perform some persuader activity for Corporation X, then for all other clients of that consultant or attorney, even if they don't perform persuader activity, but if they perform labor relations advice or services, a much broader term, they must report all the receipts and disbursements that they receive from those other clients. The result is that you may retain an attorney or a consultant unknowingly retaining someone who does engage in some persuader activity, and find that the amounts that you have spent on that attorney or consultant then become public knowledge at some point during that year. And there's no way of knowing in advance if that will happen unless you have a very heart-to-heart discussion with the attorney or consultant that you are hiring to perform your labor relations advice or services. So you could be someone, for example, who is not interested in persuader activity, stays away from persuader activity, even might have a union-friendly policy, and end up having your the amounts that you spend for labor relations advice and services made public. And the second slide, this slide here, goes over what I've said, emphasizing that I'll use the term loosely, the innocent employer may well be dragged into a persuader activity type of reporting situation, even though they were not aware of it and did not do anything to cause it. The second employer does not have to report themselves. That's important to notice. You don't have a reporting obligation. The consultant or attorney does, and that's how the information could become public. And those records must be retained for 5 years, and as I said, that information is made public. The forms that are used, the LM21 is the form that a consultant must report labor relations, advice, or services, the one I've just discussed. So that form will give the names and addresses of all covered employers. That means employers for whom they provide any labor relations, advice, or services, the receipts or cash they receive from them, and the disbursements that they make to the officers and employees of the consultant or attorney. Those all become public. On April 13th of this year, to the surprise of many, the agency, the Office of Labor Management Services, published what they called a special enforcement policy, which I see as a sort of an Orwellian language because it means exactly the opposite of what it says. It's not a special enforcement policy, it's a special unenforcement policy. The policy they issued on April 13th indicated that until further notice, that agency will not require attorneys or consultants to file an LM21. So that's the form in which they have to report the labor relations advice or services to other employers. And what is more, neither the employer nor the consultant have to retain records for this activity until further notice. So having created this Persuader Rule and creating a situation where it would cause great concern to uninvolved employers, then on April 13th, about 2 or 3 weeks after the rule, they published this policy to say, but we're not going to enforce it for now. You don't have to file forms for now. And I have been in contact with the Department of Labor and asked them when they expect to start enforcing. And I got an appropriate answer that it has to go through a process. There has to be published a new published form for review by the public. They have to take public comment, then it has to be considered, etc. So all in all, the person I spoke to indicated that it would be probably next spring at the earliest before a new form has been developed and will be enforced. So reading between the lines, it looks like this is going to be a problem for the next administration and won't apply in the immediate future. What are the changes to the new rule, the new Persuader Rule? As I indicated before, the March 24 publication of the document titled Interpretation of the Advice Exemption. It's about 150 pages of turgid prose. If you're interested in reading it, I can provide you with a copy. At its simplest, the change is the following. Before March 24 of this year, a consultant did not engage in persuader activity, and consultant includes attorney, unless he or she had direct contact with employees. That was the fine line that existed. It was a simple rule to understand and also relatively simple to enforce. If you didn't have contact with employees, then there was no persuader activity. The new rule, and they've been signaling this, by the way, since mid-2011, that they were going to do this. The new rule says, well, now there can be indirect persuader activity so long as there is an intent to persuade or an object to persuade. So the new rule has created an extensive range of indirect activities that are now classified as persuader activities. And in this presentation, I'll refer to them as indirect persuader activities. The first of all, I need to emphasize that when I use the term employee here, it's employee as defined in the National Labor Relations Act. So it's sometimes referred to as a statutory employee. A statutory employee or an employee under the Act excludes managers, supervisors, executives. They are not employees. So when we say in the past that direct contact with employees, that meant employees who were not managers or supervisors, etc. So under the old rule, as long as the consultant or attorney's contact was with management, no reportable activity occurred. What indirect persuader activities will now have to be reported? Note again that they all have to have an object to persuade, and I could spend an entire seminar on dissecting those three words, object to persuade, but we'll leave that for another time. The activities that generally will now be considered to be persuader activities it includes the ones listed: drafting, revising written materials for presentation to employees, drafting a speech for presentation to employees, drafting audiovisual multimedia materials for employees, drafting website content for employees, planning, conducting individual employee meetings, planning group employee meetings, training supervisors and employee representatives to conduct group employee meetings, coordinating or directing activities of supervisors or employer representatives, conducting seminars for supervisors and employer representatives. So very typically an employer who's concerned about union organizing may call someone in, and often it's a law firm, to meet with managers to coach them on what sort of activity they should watch out for, what they can do and what they can't do, and some ways of blunting union organizing activity. Those sort of seminars are now considered persuader activities and would have to be reported. Establishing employee committees, that's, in my experience, fairly rare. Developing personnel policies or practices. Now, you think that's very broad, and it's not all personnel policies or practices, but the agency says policies which have the object to persuade employees not to join a union or support a union. So, for example, if an employer is aware that a union is organizing and is using as an organizing tool the fact that the employer doesn't have binding arbitration for terminations, and they call on an attorney to develop a policy which would address that issue and would create binding arbitration under the employer's personnel policy, that would be considered by the agency a persuader activity in those circumstances. The final bullet there, identifying employees for discipline, reward, or other targeting. I don't know who does that. I've never done that, but I suppose it's possible it happens. So that would be considered persuader activity. And so we come to the key point here and the reason for this presentation, the effective date of the new rule. The Federal Register, which is where the rule was published in March 24 of this year, said with regard to the effective date, and I've quoted the language in full because it's significant. This final rule is effective on April 25, 2016. I have no idea what that means. Nothing seems to have gone into effect on April 25, but that's what it says. The rule will be applicable to arrangements and agreements as well as payments, including reimbursed expenses, I think it should be expenses, made on or after July 1, 2016. So I think the next slide will pull this apart. So the rule applies to arrangements and agreements made on or after July 1, 2016. And the term arrangements and agreements is from the statute. I don't know what an arrangement is that's not an agreement, but we focus on agreements. That seems to cover both. It also applies to all payments made on or after July 1, 2016. We were under the impression, and I think everyone was, because I didn't hear anything to the contrary, that the rule applied to either agreements made on or after July 1, 2016, or to payments made after July 1, 2016. It didn't. The language, if I'll just go back and show you again, the language did not seem to link those two. So the final rule is effective on April 25. The rule will be applicable to arrangements and agreements as well as payments made on or after July 1, 2016. I was asked by several people, well, if we had an agreement before July 1, 2016, and the payments were as a result of that agreement, wouldn't that be exempt from the new rule? And my answer was, and I think everyone's answer was at that time, no, that would not be appropriate, because those two seem to be in the disjunctive, and they seem to be agreements and payments. And then to our surprise, let me go back. On May 26th, OLMS held a seminar to explain the new rule, and right at the end of it, and if anyone is really interested in this, we have the YouTube of that seminar, and it's at the 59th minute of a 60-minute seminar. A slide popped up which said, applicability of the new rule to agreements and arrangements made on or after July 1, 2016, and any transactions pursuant to those agreements. So for the first time, we began to realize that there was a link between those two, and it was not agreements and payments, but it was agreements and the transactions pursuant to those agreements that were exempt from the new rule. And what it means that the old provisions, the old definition of persuader activity would apply to those agreements. The commentary, the speaker commenting on that slide in the presentation didn't say very much different. To the new rule applies to agreements and arrangements made on or after July 1, and the agreements and arrangements entered in before that date will use the prior form and instructions of the advice exemption. So they're not covered by the new interpretation. So this became, by the week of June 13th, this OLMS interpretation started becoming more widely known. And on June 14th, I contacted a high-level OLMS employee who's been very cooperative with me on other areas. And I posed a series of specific questions to that official, and a couple of days later, he sent a response to my contact, and he responded precisely to the questions that I asked. And the responses are summarized here on this slide. So if an employer agreement with a consultant has an effective date before July 1, 2016, and the services would not have been reportable under the old rule, i.e. indirect persuader activities, such services are not reportable under the new rule, even though those services would be reportable if the agreement was signed after July 1, 2016. So it became clear that the agency was grandfathering in all respects agreements with consultants and attorneys that had an effective date before July 1, 2016. And this question's come up as well, so I want to emphasize that the agreement has to be before July 1 because it applies to agreements on or after July 1, 2016. So effectively, the agreement has to be in place by June 30th. In the questions I posed to OLMS, I asked a series, and one of them was, is there any problem if the agreement is a multi-year agreement? No. It was still the exemption was still applying, provided it was entered into before July 1, and provided it remains continuously in effect. So if an agreement is ended and then restarted, that was unlikely that that would be exempt. So it doesn't matter when the agreement was entered into, so long as it was before July 1, 2016. Could it be June 30? Apparently so. That would be timely. As a result, as you probably all have been inundated by bulletins and calls probably and letters, a lot of people are urging employers to consider entering into agreements for that date, and for good reason. Some existing agreement questions. Does the grandfathered exemption apply to services under an existing agreement which is modified to expressly add indirect persuader activities? And the answer I would say to that is yes. A lot of attorneys, and we're part of that group, have engagement letter agreements or forms of agreements with our clients that don't get very specific and have a general provision that that states that we'll provide legal services to the client, and there may be a specific matter for which we retained, and then there'll be a general clause in any other legal issues that arise or which we are called upon to advise, etc. So that probably is sufficient, but it's our recommendation, we were recommending to our clients, and have been for the last week, that it would be safer to have a modification to an existing agreement which expressly addresses the indirect persuader activities. In other words, which would list those activities which will, after July 1, be considered reportable persuader activities, and agree that that's part of the agreement to provide services.
Just give me a call back. Thanks.
Bye. Does the grandfather exemption apply to services under an existing agreement which is clarified? I think the same answer, whether it's a modification or clarification. The answer again would be, it would appear so. Yes, that would be a safe place to be. Does the grandfather exemption apply to services under an existing agreement which does not specifically cover indirect persuader activities? In other words, if there's a general agreement, say that a law firm, and I'll use law firm for the moment, is retained to provide labor and employment services to the client, would that be sufficient to be grandfathered? I would say in theory, yes, but less certainty here and definitely more risk. We're indicating to our clients that if you want to sleep better at night, you might want to consider something more specific than that. Does the grandfather exemption apply to services under an existing unwritten agreement? Again, in theory, yes, but this becomes much more problematic because now is a question of proof. When was the agreement entered into? What did it cover? So therefore, much less certainty and even more risk than the first bullet on this slide. So that's not neither of these are recommended. Now, here's a question that we've discussed internally in the last week. There can be multiple agreements with multiple law firms or multiple consultants for that matter, so long as they're all entered into before July 1, 2016. And we're not recommending that you stick with one law firm or even one consultant. We think it's in the interests of an employer to consider having multiple arrangements. One is good, two is probably better. There are reasons for it. We think that's in the interests of employers and even our clients to consider this. Law firms may close. This is not an indication that there's anything in the pipeline for Foley and Lardner to do anything like that. But and you know, we're offering advice to our clients who have relationships with other organizations as well too. So law firms may close, and if you're stuck with one law firm, for example, and that law firm ceases to practice law, you may be stuck without a grandfathered agreement. Or they may cease performing those services, and it would lead to the same problem. More likely, probably in the last two, is that conflicts can arise, which would prevent certain attorneys or law firms from representing a specific employer. And ethically, lawyers cannot act when there is a conflict, and would have to the rules applicable to attorneys would require them not to act. So again, that might be a situation that could cause a problem if you only have one agreement. Or as well, an employer may be driven to different law firms for budgetary reasons, and would want to be able to again hedge their bets. And I'm sure I know there's a number of corporate counsel on this call that you can think of other reasons why it may be advisable to have more than one agreement. One certainty that does exist is that while there is some uncertainty about which agreements are grandfathered, I think we can point, as I did earlier, to those agreements which we can say with a high degree of certainty are grandfathered. And while there may be some uncertainty about verbal agreements or non-written agreements or agreements which don't specifically address the issue of provider of Persuader Activities, there is no uncertainty about the agreements that are definitely are covered, and they are agreements that are entered into on or after July 1, 2016. There should be an on or after there, by the way. I don't want to mislead you on that. They are covered by the new rule, and the range of reportable Persuader activities for such agreements, as we have noted, will be greatly expanded to cover activities that have been performed traditionally for the last 40 years, will now have to be reported. So that's the presentation and the substance of the grandfathered rule. But I did want to bring people up to date on another area of challenge to the rule, and that is the immediately after the rule was, within a week, I suppose, of the rule being published, lawsuits began to be filed. And there are currently 3 lawsuits in 3 different jurisdictions that have been filed, and they're at various stages of development. The first case to be filed, as you can see, 6 days after the publication of the rule, is the Associated Builders and Contractors of Arkansas versus Perez and Perez, the Secretary of Labor. At the time it was filed. The case is complicated. There's a number of reasons for the filing, very lengthy complaint, and constitutional grounds, statutory interpretation grounds, breach of rules of regulatory enforcement, etc. The Department of Labor, certainly last time you checked, has not yet filed an answer, but that's not where the action is. The action is that the plaintiff in the, there's a typo there, that should be S apostrophe. The plaintiff's motion for preliminary injunction was filed as well and has been fully briefed and heard. The hearing was on May 9th of this year. I was not there, but I've heard from some people who were present at the hearing. It was an unusual hearing in that the judge said nothing apart from formalities, inviting people to speak, thanking them for their presentation, and then saying they'll take it under advisement. No comments, no questions, nothing to indicate in any way what way the judge might rule. I don't know how much stock we could put in it. The judge, she was appointed by President Obama, so there's some thought that she may be have a more liberal, more pro-union bent than others. I have no idea whether that is accurate or not. And a lot of people have appointed judges find out that they do not necessarily rule the way they think they're going to rule. So whether there's anything stock can be put in that, I don't know. But that case is very well developed. As you can see, it was heard on May 9th. So it's been now before the judge for some 6-7 weeks. There is a belief that there will be some decision before July 1, 2016, and you would think so. This is such an important issue, and the fact is going into effect on July 1 would indicate that the court is likely to make some ruling of some kind before July 1. But moving on to I think I've skipped over one here. Yes, the second case that was filed was in Minnesota, Lardner et al. Versus the United States Department of Labor. There was also a motion for a temporary restraining order, which was fully briefed. An oral argument on that one was heard on May 26th, and there's no ruling yet on that. The final one, which is perhaps the most interesting and intriguing, is a case that was filed in Northern District, Texas, and in Lubbock specifically, and that's the National Federation of Independent Business et al. Versus Perez, the same Perez. And there's an update on that when we put this slide projection together. We said no motions filed. In fact, their motions have been filed in that. There has been a hearing on the motion. The judge in that case is interesting. It's Sam Cummings. Sam Cummings is the senior district judge in Lubbock, and he was appointed by Ronald Reagan. So as you can tell, he seniors in two senses of the word, and he apparently has a reputation of being, he's a good judge, a very experienced judge, and also being a somewhat conservative judge. So there was, I'd heard from some sources that there was concern that this case was behind the others. Well, it seems to have leapfrogged over them, because the latest we heard this morning, just before this presentation, was that the judge has asked the parties to submit proposed orders by 9 a.m. this Monday. So there's all indications that at least in this case, the National Federation case, the court appears to be ready to issue some form of order as early as next week. And again, it's hard to predict how a judge will rule, by who appoints them, but there's some indication that that court may be more favorably disposed to granting injunctive relief than the other two courts. But that is pure speculation. So to update this slide, we said the Arkansas and Minnesota cases could have decisions before July 1. We would add to that the Texas case is also in there and may well have leapfrogged over the other two in terms of who's going to be first out of the gate. I'm sure there's a question in your mind, well, what happens if a court in, say, Texas enjoins the enforcement of this rule? Will that affect you in your state? And the answer is we don't know. It depends. It could well. This is a national act that is being challenged. It's a federal act. It's an act that has effect throughout the country, and it's quite likely that a federal judge in a case will issue an order that will have an impact on the entire country. Excuse me. So it could be limited in its scope. It could be broad in its scope. Of course, we don't know. But the likelihood is that a federal court will issue an order that addressing a federal statute that would have an impact beyond that particular jurisdiction. I should point out that Arkansas was probably earmarked as the court that they would want to be in the first place, because there have been challenges to the provision that I addressed earlier on, the provision that if a persuader does, if a consultant does persuader activity for any employer, then all employers for whom it performs labor and employment services will have their fees and their expenses published to the world. That provision was challenged in the 1980s in Arkansas, and the Eighth Circuit in Arkansas ruled in favor of the employer. 4 or 5 other circuits have ruled the other way. So Arkansas has at least a history of being less receptive to this rule than the other jurisdictions, and that may well be the reason why they filed there. So the likelihood is that we will have some decisions next week, and there is a theory that the OLMS softening or liberal interpretation of its timing, so that it wouldn't apply to services performed pursuant to agreements that were entered into before July 1. Some people have theorized that may have been designed to make their case on the enforcement of the rule better, because it makes them appear less dictatorial and less interested in retroactive type of enforcement. As I said, there's a significant range of possibilities, but if the injunction is granted, it's likely to affect all jurisdictions. So what are the next steps that we see? We're not alone in this, but we have developed language for a pre-July 1, 2016 agreement. It could be characterized as a clarification of an existing engagement agreement, or it could be characterized as an addendum to an existing agreement. at least one of the people on this call yesterday signed an addendum to an existing agreement. So this is a client call. We only invited clients to this call, so we're not soliciting for business from non-clients. We'll send the sort of language we're looking at to anyone on the call who requests it. Just send us an email, and we'll get that to you. Just remember, it has to be done by June 30th. With regard to the pending court cases, and since that there's action been on this since we even put this presentation together, we'll be continuing to monitor the cases and any future cases that are filed. I don't think there's going to be any. The 3 cases that have been filed are probably sufficient at this point to get the issue well addressed. But we'll monitor these cases. We will send out a special bulletin as soon as we've heard any news of substance. We're going to send it to all clients on our employment law update list. As clients, I imagine you are all on that list. If you're not, or you're not sure, again, shoot us an email and we'll make sure that you're on that particular list. It's possible that that we will hear something as early as this coming Monday, the 27th. If anyone wants to know immediately, that as soon as we do, again, if you want to email us a contact number where we can call or text, we'll do that. We'll be watching this very carefully in the next week or so, and get that information out. So we're a little ahead of time, but that's probably a good thing. That's the presentation that we intend to give, and we're happy to take questions at this point. David, are you still on the call?
Yes, I am, Greg, and we've received quite a few questions here. So we'll start going through those now and start addressing them while we still have some time. So here's one question that did just come in, Greg. The question that was asked was,
is that on a screen somewhere, or are you just going to tell me verbally?
I'll read this one out just so
all right. Okay. All right. Thank you. This
one's easy enough. Some clients have asked whether an agreement just has to be signed by June 30th, or does it also have to be received back by Foley or another consultant by June 30th?
The agreement has to be entered into. So if it's that, so long as the agreement is executed, it's a good question. When I had the exchange of questions and answers with the Department of Labor, the OLMS person, he did use the word executed, and that the agreement had to be executed. I think it was the words he used. If we send something to a client and they signed it, at the moment they signed it, that's an executed agreement.
Next question, David.
So another question that we received is, so if a facility within a company has a union already, is it still necessary to have an agreement established prior to the deadline of July 1st?
Yes. And the reason for that is that I suppose qualify the yes by saying unless the union represents every employee in the facility, there's always the possibility that there's some groups of employees who are not organized and not covered by union representation. So for those employees, persuader activity could occur. So, for example, if a union represents a sector of the workforce and there's another sector that's not represented, and the employer becomes aware of organizing commencing and wants to have a seminar on avoiding union organizing, for example, if there's no agreement in place and it calls in an attorney or a consultant to advise on how to rebut this organizing, that would be persuader activity and would be reportable. So the answer is, I think yes. How was it phrased? I think you should have an agreement.
Want to just go through the list of questions, Greg? Or David, we've gotten quite a few.
Sure, yes, we do. So another question we received was, is it necessary to have billings with a firm that we sign a persuader engagement letter with?
No. That's a really good question. I talked to a client the other day, and they said the chances of us needing this are remote. Why should we bother? And my answer was, think of it like catastrophic insurance. Most likely you won't suffer a catastrophe, but if you do, you're going to be so glad you had that insurance policy. So it's like that. The chances may be remote that you would need to exercise that part of the agreement, but if you do, you'll be glad that you have the agreement. But getting back to the question, no, there's no obligation to use that firm or any firm for that matter.
And so another question that we received, if that's it for that one, another question that we received was, if we turn an employment claim over to an insurance company for defense, are we exempt because the insurance company is the quote-unquote responsible party?
I don't know how an insurance company, that sounds like it's more of where there's a lawsuit filed by an employee, right, or similar activity, and that wouldn't be covered by this rule. And there's a reason for that. I haven't gone into the exemptions, the statutory exemptions that apply to that have been there forever since the statute was passed. And one of the exemptions is lawsuits filed in federal or state court. So you could engage in what would be otherwise persuader activity, but if it arises out of a lawsuit or out of collective bargaining or out of an arbitration under a union contract or out of an NLRB unfair labor practice charge, all of those are exempt from the Persuader Rule, and there's no reporting obligation. So, but and collective bargaining is a classic example because a lot of employers use attorneys as chief spokespeople in collective bargaining, and they have direct contact with employees, sometimes away from the bargaining table even, and that's exempt. That's not covered by the Persuader Rule.
All right, moving on to the next question. This one, does this, I'm assuming it is persuader activity in general or this change in general, does this just involve organizing activities and not already organized union sites?
That's a really good question. It's principally organizing or unorganized employees, but it could arise even when employees are organized. It's less likely in those circumstances to arise in those, but it could. It's not limited to new organizing or unorganized employees. I'm not sure if that answers the question adequately.
One question that was asked early on is where do we get the necessary forms to file for these engagements.
For engaging the attorneys?
Unfortunately, there's no further clarification.
I think that's what it means. Where do we get this agreement?
Okay. Email us. We'll get it back to you immediately. If the question is about reporting, the forms are on the Department of Labor OLMS website.
So here, another question that we received recently. Does a signed agreement protect an employer from being included in disclosable receipts, etc., resulting from agreements entered into after July 1st with other clients? This one's a bit lengthy, so if you do need to refer to the Q&A.
I think I understand it. No, it doesn't. The agreement protects the client or employer from being covered by the new rule, and it applies the old Persuader Rule, so that if it was with an agreement in place, the employer can continue to use attorneys and consultants as they have in the past without having to report. But as I said earlier on, if a consultant or attorney performs persuader activity for another employer, not your company, then once they get their act together and once they've decided how that's going to be, what the form is going to say, the employer will have its fees, disbursements made public because of the persuader activity at the other employer. I hope that makes sense.
Mm-hmm. So another question, we've got a couple left here. Another question we received. So it is not clear. So if you have an existing relationship with an attorney, then no agreement is necessary, followed by it would be advisable to have an agreement. So which is it? This question came in just a few minutes ago, so they might be referring to one of our more recent statements here.
David, can you repeat the first question?
Sure. So the exact wording, so it is as clear as mud. If you have an existing relationship with an attorney, then no agreement is necessary, followed by it would be advisable to have an agreement. So which is it? I think they're just looking for some clarification on the relationship and the necessity of an agreement.
Yeah. Well, it's not I'm happy to clarify that. You could have an existing relationship with an attorney which doesn't address the persuader activity. So you could have an existing relationship with an attorney, for example, for doing intellectual property work. And I would be worried that wouldn't be broad enough to cover persuader activity. So when we say it's advisable to have an agreement, we're saying it's advisable to have an agreement which addresses the Persuader Rule and makes clear that the types of activity that the government says will now be reportable are actually covered by the agreement. So an existing relationship with an attorney is not enough, in my view, to be safe. You have to have the sort of relationship that exempts you from the new rule.
And sort of a similar question, which we received at a similar time. Any downsides to casting an extremely wide net with the law firms or consultants with whom you enter into these agreements prior to July 1st?
Does that mean many law firms, or many consultants?
I think
so.
No, there's no downside to that. No.
This one's a long one, and you may want to consult the text on this one as well. So the question on this one was, if you have an agreement with a consultant in place prior to July 1st, and they perform reportable activities at a different employer, are you excluded from being included in the consultant's reporting requirements, which includes all of their activities?
No. You're not excluded. There's no, let me emphasize this, I should have done it before. There's no way to enter into an agreement with a law firm or consultant which protects you against having your receipts and disbursements disclosed to the world because that attorney or consultant engaged in persuader activity at the other employer. There's no agreement that's going to protect you from that.
Coming down to the end of the question here.
There's one there. Who should we send the email to?
So who should we send an email to regarding obtaining the suggested language or an addendum?
Is our email address on the front of this? Oh, maybe not.
Let's give both. It's Kevin Hyde. It's KHYD as in David E at Foley.com. KHyde@Foley.com. Greg, you want to give yours?
Yeah, G McClune, GMCCLUNE @Foley.com.
And either one, we will get you a copy of the agreement.
Or if you have an existing relationship with an attorney at Foley and Lardner, a labor and employment attorney,
right,
send it to that person.
And similar question, sort of piggybacking off of that one, for clarification, to be clear, if we have already retained Foley and therefore the employer does not have to file, I think that's just a question for further clarification on making that addendum.
No, we still need to have the new, either an addendum or this new agreement. Even if you're a current Foley employee or client.
It's certainly highly advisable. And we could, there's going to be some slip through the cracks, I'm sure, and we'll probably argue in the future that our agreement was broad enough to cover this, but, why take the risk? Think of the catastrophic insurance part. It's much better to have an agreement that specifically says these types of services are covered by our agreement.
All right. Well, that is it for the majority for the questions that we've received. If you have any further questions, please do enter them into the Q&A widget while we still have a few minutes here. We'd like to answer any other final questions that you might have before we sign off here.
But thank you all for joining us on this. We understand that it is a confusing topic.
Oh, it's not that confusing.
It started out in a series of confusing events.
All right.
Well, then in that case, at this time, we will close things out here and finish up. Again, if there are any further questions, please feel free to consult the program registration or the program file for contact information for both of our speakers here. And we will be following up with a notice as well with contact information included there. So,
David, I see there's one question we didn't answer. Is the Chief Human Resources Officer is not personally responsible, but the CFO is?
And why is that?
Why is that? That's what the statute says, and that that's who they're held responsible.
And okay, and yep, that does do it for the questions that we've received. And again, if there are any further questions or questions that are potentially too sensitive to talk about publicly here, do reach out to either Greg or Kevin here, and we will be following up with you all with contact information there. So thank you again for joining us.
Thank you, everyone.
Thank you.